各位观众大家好，欢迎收看邓宏说法节目，我是美国联邦律师邓宏，让我们知法守法，据理力争。继续回到我们所关心的弗洛伊德的案件我们知道这个案件已经进入了最后的审理程序。在最后的审理程序里边的话，分成4个步骤。第一个步骤，法官会给陪审员这个指示，因为这个指示非常重要每一个州都有每个州的刑法，但是刑法里边的话，它往往是非常笼统的，没有具体的这个成分在里边，所以法官会跟辩护律师、检察官3方进行讨论，根据这个刑法，我们要针对这个案件要具体证实哪些成分才能够罪名成立，所以这个 jury instruction 非常重要。给完这个 jury instruction 之后，检察官有举证责任，所以他先会提出证据证实，进行结辩的陈述结辩陈述完了这个之后，进了第3步，辩护律师可以进行辩护的陈述。他结案里边的话说，证据哪些有哪些证人说明他没有没有这个触犯这个刑法，所以进行这个辩方的结辩。因为举证责任在检察官，所以检察官跟传付证人一样，他可以进行陈述，进行反驳的陈述，所以这个部分会进行第4个阶段。在4个程序都走完之后，这个案件会交给陪审团进行研判。这个 deliberation 的最重要是闭门的，不会跟外界有任何接触，让他们这个12名陪审员来研判。所以根据法官的 jury instruction， 过去2个星期听来的证人有没有证实这3项罪名的成立。所以很重要一点的话， jury instruction 往往是给陪审员一个指标，一个说明书，这哪些罪名要哪些成分才能证实的。我们听听这个法官 Cahill 在给陪审员指示的时候做的一些说明。
Anything that you may have heard or seen elsewhere about this case. I have not, by these instructions, nor by any ruling or expression during the trial, intended to indicate my opinion regarding the facts or the outcome of this case. If I have said or done anything that would seem to indicate such an opinion, you are to disregard it.
所以这个很重要。法官首先声明，他说我是个法官，真正决定他是否有罪是在你们陪审团手上，陪审团是决定事实的裁判者。我作为法官在审理过程之中会做出一些判决，这些判决的话，哪些证据可以作为承认证据，哪些不能作为承认证据检察官或者是辩护律师有可能提出这些反对的动议，我做了一些裁决，这些裁决以后很有可能被你们误会我是偏袒了辩护律师或者偏护了检察官，以后有可能陪审员会误以为这个因为法官是懂得法律的，了解这个程序的，他比较袒护判了案好像对辩护律师有利，有可能是辩护律师有理。他说这种的话都是误会，所以你不要理会我的裁决，以后真正决定权是在你陪审员手上。
You must consider these instructions as a whole and regard each instruction in light of all the others. The order in which the instructions are given is of no significance. You are free to consider the issues in any order you wish. The defendant is presumed.
所以很重要一点呢，他说我会给你这次 instruction 的话有3项罪名，这3项罪名的话这个2级谋杀、3级这个谋杀还有2级误杀罪，哪一个顺序不重要，前后顺序不重要，你可以根据这些证据里边的话来自己来调整一下子，以后先考虑哪一个还不考虑哪一个，这是你们的决定。
Innocent of the charges made. This presumption remains with the defendant unless and until he has been proven guilty beyond a reasonable doubt. The fact that the defendant has been brought before the court by the ordinary processes of the law and is on trial should not be considered by you in any way suggesting guilt.
所以这点很重要的话，这次就是无罪推定论了。他说你要知道这个被告做的被告词上面，你不能够就误以为他一定有错才会被起诉。所以很重要一点，美国宪法保证民众的无罪推定论，也是在他被判有罪之前，他都是清白的，都是无罪的，所以不要这个误以为他被指控他就有罪。
The burden of proving guilt is on the state. The defendant does not have to prove his innocence.
这个很重要的话，他说举证的责任在检察官，被告没有这个责任来证实自己的清白，是检察官必须拿出证据证实被告有罪。
Proof beyond a reasonable doubt is such proof as ordinarily prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt.
他是很重要一点的话，他说检察官有举证责任，并且他的标准是 beyond reasonable doubt， 必须敲出合理的怀疑。合理的怀疑，他说普通的人会不会有这种怀疑，所以不是说 100% 100%的这个没有理由，而是说合理的怀疑，它应该超越出里边去。当然这个标准里边的话，我们刑事界里边呢常常说 beyond reasonable doubt 的话，就像一个案子的成立，像民事告的话，它一般的话这 preponderance of evidence 这个话就说50+1有可能有这个它是有罪的，这个是50+1。以后 beyond reasonable doubt 往往是90%以上你大概90%以上是他做的，所以这种的话叫 beyond reasonable doubt， 你不可能 100% 绝对没有任何怀疑，这个怀疑必须是合理的。
A fact may be proven by either direct or circumstantial evidence, or by both. The law does not prefer one form of evidence over the other. A fact is proven by direct evidence when, for example, it is proven by witnesses who testify as to what they saw, heard, or experienced, or by physical evidence of the fact itself. A fact is proven by circumstantial evidence when its existence can be reasonably inferred from other facts proven in the case.
他说陪审团在考虑证据的时候可以考虑两类证据，一个是直接证据，一个是间接证据。这两个证据的话，没有说哪一个证据更有效，哪个证据没有这个效率没有那么高，所以的话两个都同样的具备法律的效果所以的话这个直接证据当然就是有证人亲眼看见，这是叫直接证据。间接证据就是有一部分的话透过专家证人还有其他的这个证物里面显示出来的，这叫间接证据。这两个的话在法庭上都有同样的法律效用的。
For example, if a person watches deer crossing a snow-covered field, the person has direct evidence of deer walking in the field because the person sees it. If the person does not see deer but finds deer tracks in the snow, the deer tracks are circumstantial evidence that deer walked in the field because that factual conclusion can reasonably be inferred from the tracks found in the snow.
所以这点的话就是他的举例，这法官举例说，就是说好像我们要证实在大雪天里边的话有一个鹿走过了田这个田里边走过来，所以的话我们可以提供证据证实有人看到这个鹿的话从田里边走过来这是直接证据，我们可以考虑。但是从另外一个角度的话，虽然没有人直接看到了这个 deer 这个鹿的话从田里边过去，但是在田里边我们可以在雪天里边看到里边的这个鹿的这个脚印，这个脚印里边我们可以检视出来，鹿有可能就是这个在雨天里边在大雪天里边走过了田里，所以这个部分这是属于间接证据，这两个证据都可以作为呈堂证据的。当然除了这个部分的话，这个是陪审团可以考虑证据之外，他也是针对这个具体的哪些证据才算这个才能构成这三个成分里边的话这个 Cahill 法官的话也是做了一部分的解说。所以这个解说很重要，因为的话哪一个萝卜一个坑，它的标准是什么二级谋杀罪是什么，三级谋杀罪是什么，二级误杀罪又是什么的话，我们听听法官里边的解说。这个就是根据明尼苏达州刑法还有双方律师协商最后得出来的这个说明。
The defendant is charged in count 1 with murder in the second degree in connection with the death of George Floyd. Under Minnesota law, a person causing the death of another without intent to cause the death of any person, while committing or attempting to commit a felony offense, is guilty of the crime of murder in the second degree. The defendant is charged with committing this crime or intentionally aiding the commission of this crime. The elements of the crime of murder in the second degree while committing a felony are: first element, the death of George Floyd must be proven.
所以很重要一点的话，他说现在弗洛伊德这个案件里边警察 Derek Chauvin 面临这个二级谋杀。二级谋杀在根据明州的法律规定，是因为他在犯重罪过程之中造成他人的死亡，这种的话，这个成分具体的成分的话，他开始说明说，第一要首先证实这个弗洛伊德死亡。
Second element, the defendant caused the death of George Floyd.
第二个成分是要证实这个被告沙文造成了弗洛伊德之死。
Third element, the defendant at the time of causing the death of George Floyd was committing or attempting to commit the felony offense of assault in the third degree.
所以这个在这个第三个成分，就是说在沙文造成弗洛伊德死亡过程之中他触犯了明州的这个攻击罪，3级的攻击罪。
It is not necessary for the state to prove the defendant had an intent to kill George Floyd, but it must prove that the defendant committed or attempted to commit the underlying felony of assault in the third degree.
所以很重要一点的话，他说陪审员这个检察官不需要证实他们是有意图这个Derek Chauvin 他是有意图去杀害这个弗洛伊德的，他只要证实的话，当时这个警察是有意图去伤害这个弗洛伊德。
There are two elements of assault in the third degree. First, defendant assaulted George Floyd. Assault is the intentional infliction of bodily harm upon another, or the attempt to inflict bodily harm upon another. The intentional infliction of bodily harm requires proof that the defendant intentionally applied unlawful force to another person without that person's consent, and that this act resulted in bodily harm. Second, defendant inflicted substantial bodily harm on George Floyd. It is not necessary for the state to prove that the defendant intended to inflict substantial bodily harm or knew that his actions would inflict substantial bodily harm. Only that the defendant intended to commit the assault, and that George Floyd sustained substantial bodily harm as a result of the assault.
所以这个法官解释的话，他说刚才说过，他这个二级谋杀罪不是说要证实弗洛伊德当时的话就是 Derek Chauvin 是有意图去杀害弗洛伊德的，他只要证实是3级攻击罪。所谓的攻击罪的话，他是有意图这个想办法来这个伤害，有意图去伤害，或者是在过程之中里边他是有这个犯罪意图是攻击弗洛伊德而导致他受伤死亡的。所以这个部分的话，他只要有这个要证实这个沙文当时是有意图去伤害弗洛伊德。
Fourth element, the defendant's act took place on or about May 25th, 2020 in Hennepin County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty of this charge.
所以这点的话，第四点的话，这个事情发生在 Hamilton 这个地方，所以它4个成分，它要证实的这个弗洛伊德死亡这个死亡是Derek Chauvin 所造成的，并且 Derek Chauvin 在攻击过程之中有意图去伤害这个弗洛伊德，这个事情的话发生在这个 Hamilton 这个地方，所以这个4个成分成立的话，这项罪名才能够成立。任何一个成分没有成立的话，这项罪名就没办法成立。所以4个成分必须要一致在同时存在才能够成立。
If you find that any of the elements have not been proven beyond a reasonable doubt, the defendant is not guilty of this charge, unless you find the state has proven beyond a reasonable doubt that the defendant is liable for this crime committed by another person or persons according to the instructions below that are listed on page 8 under the heading Liability for Crimes of Another. The defendant is charged in count 2 with murder in the third degree in connection with the death of George Floyd. Under Minnesota law, a person causing the death of another by perpetrating an act eminently dangerous to others and evincing a depraved mind without regard for human life, but without intent to cause the death of any person, is guilty of murder in the third degree.
所以这一点的话，就是说，这个刚才讲过，4个成分必须要一致成立。如果是任何一个成分没有办法成立的话，这项罪名就不成立了。所以这是他提到这个第2项罪名的话是3级谋杀案。3级谋杀案的话，就是说这个 Derek Chauvin 在伤害这个弗洛伊德过程之中，他是很残忍，以后 depraved mind, depraved heart 这个心里边很残忍，所以这个残忍的话，它是怎么定义呢？
The defendant is charged with committing this crime or intentionally aiding the commission of this crime. The elements of the crime of murder in the 3rd degree are: first element, the death of George Floyd must be proven. Second element, the defendant caused the death of George Floyd. Third element, the defendant caused the death of George Floyd by an intentional act that was eminently dangerous to other persons. A person commits an act eminently dangerous to others when the act is highly likely to cause death. Fourth element, defendant acted with a mental state consisting of reckless disregard for human life. The defendant's act may not have been specifically intended to cause death, and may not have been specifically directed at the particular person whose death occurred, but must have been committed with a conscious indifference to the loss of life that the eminently dangerous act could cause. Fifth element, the defendant's act took place on or about May 25th, 2020 in Hennepin County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty of this charge. If you find
所以这一点的话，就是说第2项罪名的指控是3级谋杀罪，它必须要证实5项罪名5项的成分。第一个，弗洛伊德死亡了；第二个，他的死亡是 Derek Chauvin 所导致的；第3项里边的话，它是有一个 intentional act， 它有意图去进行一个攻击罪，所以这个攻击未必要伤害别人，它有意识这部分去。第4部分的话，它是这个叫做 mental state，mental 它的意图里边的话，它有这个所谓的 reckless 的话，鲁莽的以后置于他人的安全不顾，所以他有这意图去做，并且的话，这意识上面的话，他不理会别人的死活，这种的话就是第4个第3个跟第4个的成分。然后第5个的话这个事情发生在 Hempton 这个地方，所以必须要证实5个成分第一个很容易证实弗洛伊德死亡了，第2个就是这个沙文导致的但是最重要的话，第3个在犯案过程之中，沙文有没有意图去犯罪，这个犯罪里边的过程之中会造成这些危险，他根本不理会，所以这个是第3跟第4个成分。所以非常就让陪审团有没有足够证据证实的话他当时知道自己在犯错，并且他不理会这些危险，所以这个的话是第2项的指控，也是3级谋杀罪的具体的成分。
Find that any of these elements has not been proven beyond a reasonable doubt, the defendant is not guilty of this charge, unless you find the state has proven beyond a reasonable doubt that the defendant is liable for this crime committed by another person or persons, according to the instructions that are listed on page 8, under the heading Liability for Crimes of Another. The defendant is charged in count 3 with manslaughter in the 2nd degree in connection with the death of George Floyd. Under Minnesota law, whoever by culpable negligence, whereby he creates an unreasonable risk and consciously takes the chance of causing death or great bodily harm to another person, causes the death of another, is guilty of manslaughter in the 2nd degree. The defendant is charged with committing this crime or intentionally aiding the commission of this crime. The elements of manslaughter in the 2nd degree are: first element, the death of George Floyd must be proven. Second element, the defendant caused the death of George Floyd by culpable negligence, whereby the defendant created an unreasonable risk and consciously took a chance of causing death or great bodily harm. Culpable negligence is intentional conduct that the defendant may not have intended to be harmful, but that an ordinary and reasonably prudent person would recognize as involving a strong probability of injury to others. Third element, the defendant's act took place on or about May 25th, 2020 in Hennepin County.
所以第3项指控是属于2级误杀罪。法官解释的话，它有3个成分， 要证实的。第一这个事情发生在这个是佛洛伊德一死是因为这个 Derek Chauvin 所引起的。那第二个成分的话，在犯案过程之中，它是有就是非常不负责任的这个疏忽行为。这个疏忽行为的话，它不一定是要求这个不需要证实 Derek Chauvin 这个警察他是有意图去伤害弗洛伊德，而是说他过程之中他明知道这个 Derek Chauvin 的话弗洛伊德有生命危险，他并没有采取必要的措施来抢救。这个部分里边的话所以他是说这个警察因为他的疏忽而导致Derek Chauvin 这导致弗洛伊德的死亡。所以这个部分的话，第三项指控这项就是属于误杀罪这个是因为他不是要伤害不需要证实Derek Chauvin 这个警察有意图去伤害弗洛伊德，但是就是因为他的行动导致他的疏忽行动没有的采取措施导致Derek Chauvin 这个导致弗洛伊德的死亡。所以整个案子可以看得出，现在法官已经给陪审团3个不同样的成分这个标准。所以将来的话，陪审团会根据这个过去2个礼拜检察官跟辩护律师所提供的这些证据，一个萝卜一个坑。我们刚才讲过的话几个第二项罪名第一项罪名二级谋杀罪，它有4个成分这个4个成分哪些都是可以构成的第三项罪名第二项罪名有5项成分，是怎么样子一个一个成分来装在里边去，一个萝卜一个坑。如果是任何一个坑没有办法填的，没有办法找到的证据的话这项罪名就可能不成立。所以很重要一点陪审团现在已经是得到法官的指示，你陪审员就是关起门来看看的话，回顾一下子检察官跟辩护律师所提供的证人证据有没有构成这些犯罪成分。如果有构成，那这项罪名成立；如果是没有办法达成共识，这项罪名可能是留审或者是无罪。好的，谢谢大家收看这集的灯红说法节目，我们下集继续解读弗洛伊德的案件。谢谢大家的收看。